This current trends case brief presentation examines the case of an individual with initials KAM against the General Manager of the Ontario Health Insurance Plan. The case was heard on December 5, 2012 in Toronto, Ontario. The appellant suffers from TMJ disease. She has had multiple surgeries beginning in 1985 for the repair and/or replacement of her TMJ. Between 1990 and 1997, she underwent a number of such procedures in the United States with funding from her Ontario Health Insurance Plan. Her last procedure involved the replacement of her TMJ with a metal prosthesis. Unfortunately, the appellant suffered a trauma in the spring of 2010, which caused a fracture to one side of the implant. The prosthesis was then replaced with a Biomet implant. The Biomet implant functioned well until August 2011, when the appellant began to experience pain in her jaw, facial swelling and numbness, and also a decreased ability to open her jaw. She was also unable to close her eyes completely and had developed exposure keratitis in both eyes. Her symptoms worsened over time. The appellant believed that her symptoms were due, in part, to a reaction in the material of the Biomet implant. The appellant consulted Dr. James Yanni, the maxillofacial surgeon in the United States, who placed the appellant's metal implant in 1997. Dr. Yanni was critical of the procedure done by Dr. Baker and recommended replacement of the implant with a rib graft, which would improve the appellant's jaw function, relieve her pain, and restore function to her facial nerves. Dr. Baker had advised the appellant that he did not believe that further surgery should be recommended and that no surgeon in Ontario would likely agree to perform additional surgery. The main issue in this case is as the treatment sought by the appellant was not available in Ontario. Did her Ontario health insurance cover the cost of this service outside of the province? For the foregoing reasons, the appeal board found that the services sought by the appellant were generally accepted by the medical profession in Ontario as appropriate for a person in the appellant's medical circumstances. They were also not available in Ontario by an identical or equivalent procedure. The treatment sought by the appellant was therefore prescribed as an insured service under Section 28.4 of Regulation 552 and therefore eligible for funding. Dr. Yanni believed that the appellant's facial nerves had been affected following the procedure done by Dr. Baker, which had led to a degree of facial paralysis and had caused the appellant's inability to close her eyes. Therefore, as mentioned before, the appeal board found that the services sought by the appellant were generally accepted by the medical profession in Ontario and would not be available in Ontario as a procedure. Dr. Yanni also proposed to attempt decompression of the appellant's facial nerves in order to decrease pain and increase function. If this surgery was not allowed, the appellant could suffer permanent damage to her eyes, including damage to the corneas and glaucoma. The regulation provides that out-of-country services are prescribed as insured services if it is necessary that the insured person travel out of Canada to avoid a delay that could result in death or medically significant irreversible tissue damage. In Ontario, health insurance is governed by the provisions of the Health Insurance Act. In each individual case, the regulation establishes separate criteria and conditions for determining if a service is an insured service under the Act and therefore eligible for payment. Section 12 of the Act provides that every insured person is entitled to payment for insured services. The term insured services is defined in Section 11.2 of the Act. The regulation provides that out-of-country services are prescribed as insured services if the service is generally accepted by the medical profession in Ontario as appropriate for a person in the same medical circumstances as the insured person, and if it is necessary that the insured person travel out of Canada to avoid a delay that would result in death or medically significant irreversible tissue damage. The decision from this case was not stare decisis, meaning that the outcome of this case was not made with regards to decisions made on previous and similar cases. Looking at the decision of this case, I believe it was the right decision, as the prognosis for the appellant without the surgery was dismal. The decision also complied with all necessary sections of the Ontario Health Insurance Act. Question: do you believe that the services sought by the appellant are prescribed as insured services under the Ontario Health Insurance Act?